911, what's your emergency?
Hey, I'm a bus driver and one of my students just passed me a note that says his mother needs help and that his dad is hurting her.
Okay, do you have an address?
Yeah, they live on, it's the first house when you turn into the neighborhood.
Okay, officers are being dispatched now. Can you stay with the child until law enforcement arrives?
Yeah, so I'm just parked outside the neighborhood. I'll stay here.
Welcome to Echo Case File, the place where we bring you the raw, unfiltered, true stories of crime that demand to be told. I am your host, and today we launch part 1 of our special series on Oregon's most dangerous fathers. If you are watching on YouTube or listening on your favorite podcast platform, do me a favor right now and hit that like button. Leave a comment telling me which case shocked you the most so far, and smash subscribe with notifications on so you never miss when part 2 drops. Your support keeps these stories coming and helps us deliver more in-depth true crime narration. Now, without any further delay, let us dive straight into the cases. Case 1. Jared Scott Jeremy Stoller. In the quiet communities around Roseburg and Sutherland in Douglas County, Oregon, life seemed ordinary on that Sunday morning in March of 2026. But behind the doors of a modest hotel room at the Relax Inn in Sutherland, a 911 call came in shortly before 10 in the morning that would set off a chain of events no one could have predicted. 27-year-old Jared Scott Jeremy Stoller placed the call himself. He told dispatchers that his 11-month-old son, Jackson James Stoller, had vanished from the room. According to Stoller, someone had pushed in the window while the little boy slept in his car seat, and the child had been kidnapped. Officers from the Sutherland Police Department responded immediately. They arrived at the Relax Inn expecting a frantic search for a missing toddler. What they found instead were suspicious circumstances that did not quite add up. The details of the story raised immediate red flags, and soon the Douglas County Major Crimes Team was activated to take over the investigation. Detectives began interviewing Stoller at the Sutherland Police Department. At first, he held firm to the kidnapping tale, describing how he believed an intruder had taken his son right from under his nose. The account seemed plausible on the surface to anyone hearing it cold, but seasoned investigators knew better than to accept it at face value. They kept questioning him, methodically going over every detail. Slowly, the story started to change. In one version, Stoller now claimed that the child had died accidentally during co-sleeping in the early morning hours of March 12, 2026, at a location back in Roseburg. He suggested it was a tragic mishap, nothing more. Yet even that explanation did not hold water under closer scrutiny. Detectives pressed harder. After Stoller was fully advised of his Miranda rights, the truth finally came out in a confession that stunned everyone involved. Stoller admitted he had intentionally murdered his 11-month-old son days earlier by strangulation while they were still in Roseburg. Then, in an attempt to conceal the crime, he had disposed of the tiny body in the South Umpqua River. The confession was clear and direct. Stoller even cooperated further by helping point authorities toward the location. That same Sunday afternoon, March 15, 2026, the Douglas County Sheriff's Office dive team, assisted by boats from the Oregon State Police and local resources, launched a search in the murky waters of the South Umpqua River near the 3500 block of Old Melrose Road, right on the edge of Roseburg city limits. Just before 6 in the evening, the divers located the body of little Jackson. The infant's remains were carefully recovered and turned over to the Douglas County Medical Examiner's office. An autopsy was scheduled for the coming days to establish the precise cause of death beyond what the confession already revealed. By that night, Jared Scott Jeremy Stoller was under arrest and lodged in the Douglas County Jail. He faced formal charges of first-degree murder and abuse of a corpse, with some reports noting the abuse of a corpse charge specified as second degree. The community around Roseburg and Sutherland was left reeling as word spread through local news outlets. Court records from earlier in the case provided a small glimpse into Stoller's life prior to this tragedy. He had 2 children with a woman in Roseburg and, in December of 2025, had been ordered by the court to pay $100 per month in child support along with an additional $200 to cover overdue amounts. No prior criminal history in Oregon was noted in the public reports at the time of his arrest. The next day, Monday, March 16, 2026, Stoller was arraigned in Douglas County Circuit Court. He appeared before the judge as the weight of the charges settled in. The investigation remained active, with the sheriff's office asking anyone with additional information to contact them at 541-440-4471. Let us step back for a moment and retrace those critical hours once more so the full picture comes into focus. The 911 call from the Relax Inn set everything in motion. Stoller sounded urgent, describing a break-in and a missing child. Police arrived, assessed the scene, and quickly realized the story did not align with the physical evidence or the timeline. Transferring the case to the major crimes team allowed for a deeper dive. During those initial interviews at the police department, the shift from kidnapping claim to accidental death claim happened under questioning. Only after the Miranda warning did the full confession emerge, detailing the strangulation in Roseburg and the deliberate disposal in the river. The dive operation that evening was methodical, with multiple agencies coordinating to scan the South Umpqua River until the body was spotted near Old Melrose Road and West Godek Avenue. Recovery happened swiftly once located, and the medical examiner took custody. Every step followed standard procedure, yet each revelation deepened the horror for those following the case. The charges of first-degree murder reflected the intentional nature Stoller himself described, while the abuse of a corpse charge addressed the handling of the remains afterward. Arraignment the following day ensured the legal process moved forward without delay. Public records tying in the earlier child support order added context to Stoller's situation, but did nothing to explain the events of March 2026. The case stood as a stark reminder of how quickly a family situation could turn tragic when hidden intentions surfaced. As the hours turned into days after the arrest, the Douglas County Sheriff's Office continued its work. The autopsy results were pending, but the confession already painted a clear sequence. From the hotel room report in Sutherland back to the actions in Roseburg, the timeline locked into place. Stoller had been the last person with the child before the disappearance claim, and his own words sealed the account. The river location near the 3500 block became the focal point of recovery efforts, with divers braving the waters on that Sunday evening to bring closure to at least the physical search. The entire operation from 911 call to body recovery spanned less than a single day, yet the emotional impact would last far longer for everyone touched by it. Jared Scott Jeremy Stoller remained in custody as the judicial process began, facing the full weight of the first-degree murder charge that carried the possibility of life in prison if convicted. The abuse of a corpse charge compounded the severity, addressing the desecration that followed the act itself. No further criminal history complicated the picture, making the suddenness of the events all the more jarring to the public. Now let us move seamlessly into the second case of this part, keeping every detail grounded in the verified public record. Case 2. Felipe Arroyo Jr. Hundreds of miles away in Portland, Oregon, another father's actions would surface through a painstaking investigation that stretched across months and ended in arrest just before the end of 2025. 38-year-old Felipe Arroyo Jr. faced charges that stemmed from events beginning in early May of 2025. On May 4th of that year, detectives with the Portland Police Bureau's Child Abuse Team received notification that an infant was being treated at a local hospital for life-threatening injuries. Those injuries appeared suspicious in nature right from the start. The baby in question was 15 days old, identified as Arlo Darniel Arroyo. Medical staff worked urgently, but despite their efforts, the infant did not survive. Arlo passed away on May 8, 2025. The Multnomah County Medical Examiner later determined the cause of death to be homicide by blunt force trauma. With that ruling, the case transferred immediately from the Child Abuse Team to the Portland Police Bureau's Homicide Unit for a full-scale murder investigation. What followed was a months-long probe involving multiple layers of evidence collection, witness interviews, and forensic review. Detectives worked methodically, building a case that would eventually go before a grand jury. In November of 2025, the Multnomah County District Attorney's Office presented the accumulated evidence. The grand jury returned an indictment on a series of serious charges against Felipe Arroyo Jr. Those charges included 3 counts of second-degree murder, 1 count of first-degree assault, 2 counts of first-degree criminal mistreatment, 2 counts of attempted coercion, and 1 count of witness tampering. The breadth of the indictment reflected the complexity of the investigation and the severity of the acts alleged. On Monday, December 8, 2025, the moment of arrest finally arrived. The United States Marshals Fugitive Task Force took Felipe Arroyo Jr. into custody in Portland. He was transported without incident to the Multnomah County Detention Center and formally lodged on all the indicted charges. The announcement came from the Portland Police Bureau itself, confirming that after months of silent work, the case had reached this critical stage. Arlo's death was noted in local homicide statistics as the 13th of the year up to that point, part of a larger total of 45 homicides recorded in the city during 2025. Yet for the family and investigators, the numbers mattered far less than the individual tragedy. Let us retrace the timeline of this case step by step to ensure every public fact is clear. The investigation opened on May 4, 2025, when the child abuse team learned of the hospitalized infant with suspicious injuries. Hospital staff had flagged the situation, triggering the police response. Arlo Darnielle Arroyo, only 15 days old, received treatment but succumbed 4 days later on May 8. The medical examiner's homicide ruling by blunt force trauma shifted the focus to murder. The homicide unit inherited the file and spent the ensuing months gathering evidence. No shortcuts were taken. By November, the grand jury reviewed everything and returned the multi-count indictment. The arrest on December 8 by federal marshals brought the suspect into the system at the Multnomah County Detention Center. Each charge carried its own weight. The 3 counts of second-degree murder spoke to the intentional nature of the fatal trauma. The first-degree assault and criminal mistreatment charges addressed the harm inflicted on the vulnerable infant. The attempted coercion and witness tampering counts suggested efforts to interfere with the truth coming out. Every element stemmed directly from the official police and court records. The Portland Police Bureau emphasized that the case remained active for any additional tips, urging anyone with information who had not yet spoken to detectives to come forward. The investigation had been thorough from the hospital notification through the grand jury phase. Arlo's short life ended in a way no parent should ever cause, and the legal system responded with the full force of the charges filed. Felipe Arroyo Jr. sat in custody as the case moved toward further court proceedings, with arraignment details to follow in the public record. The months-long wait between the death in May and the arrest in December highlighted the patience required in complex child homicide cases, where evidence must be airtight before charges can be brought. Case 3. Emerson Cromwell. In the coastal community of Lincoln City, Oregon, on the 9th day of August in 2022, a 911 call came in that would later unravel into one of the most heartbreaking and extensively documented cases of child abuse leading to death the county had ever seen. 27-year-old Emerson Cromwell, alone with his 15-month-old daughter at their residence, dialed emergency services to report that the little girl had suddenly become unconscious and non-responsive. He described to dispatchers how she had been fine moments earlier, crawling toward him before collapsing right there in his arms. According to his initial account, he had picked her up and shaken her just one time in an attempt to revive her before placing the call for help. Responders from the Lincoln City Police Department and medical personnel arrived swiftly at the home. They found the toddler in critical condition and immediately transported her by ambulance to the Samaritan North Lincoln Hospital emergency room. Doctors there quickly determined she was suffering from a severe brain bleed, an injury far too serious for local care. Within hours, she was life-flighted to Oregon Health and Science University's Dornbecher Children's Hospital in Portland for advanced treatment. Tragically, despite every effort by the medical team, the 15-month-old passed away the following morning on the 10th of August in 2022. The Oregon State Police medical examiner conducted a thorough autopsy and ruled the manner of death a homicide caused by an acute subdural hemorrhage combined with blunt force injuries to the head. Multiple medical experts who would later testify at trial all reached the same conclusion. The only possible explanation for the extent of the brain damage was repeated child abuse trauma. Investigators from the Lincoln County Major Crime Team, which included officers from the Lincoln City Police Department, Newport Police Department, Toledo Police Department, Oregon State Police, and the Lincoln County Sheriff's Office, began piecing together the timeline. Evidence soon emerged that Cromwell had been the only adult present with the child in the hours leading up to her collapse. Text message records recovered from that day painted a picture of mounting frustration. Cromwell had been struggling to feed his daughter and had just received disappointing news regarding a clothing business venture he was involved with. Shortly after those exchanges, he texted the child's mother to say something was wrong and then called 911. Prosecutors would later argue that this sequence showed a moment of explosive anger triggered by those stressors. As the investigation deepened, additional evidence of a pattern of abuse came to light. Court records and trial testimony revealed that Cromwell had begun spanking the little girl when she was only 5 months old. He would often isolate her in her room and administer beatings that left visible bruises lasting for days. Witnesses and documentation also indicated the child was frequently left home alone during this period. None of these earlier signs had been enough to prevent the final tragedy, but they became central to the case once charges were filed. Emerson Cromwell was eventually indicted on multiple felony counts: murder in the second degree, assault in the first degree, assault in the second degree, and manslaughter in the first degree. The case moved slowly through the system, culminating in a nearly month-long jury trial that began in the summer of 2025 and concluded with a verdict on the 26th of September in 2025. After hearing weeks of testimony from medical experts, investigators, and those familiar with the family dynamics, the Lincoln County jury convicted Emerson Cromwell on every single count. Sentencing took place on the 28th of October in 2025 before presiding Judge Cheryl Bockhard in Lincoln County Circuit Court. The judge imposed the standard sentence under Oregon law for second-degree murder: life in prison with the possibility of parole after 25 years. In her remarks from the bench, Judge Bockhart described the death as violent and horrible, a tragedy the child did not have to suffer and one inflicted directly at the hands of her own father. She noted the testimony showing the little girl had often been left alone and stated that Cromwell had proven himself ill-equipped to be a father. The prosecution team included Assistant Attorney General Tobias Tingley from the Oregon Department of Justice along with Chief Deputy District Attorney Michael Thornycroft, and they emphasized throughout the proceedings that every piece of evidence pointed back to intentional abuse rather than any accident. The case drew widespread attention across Oregon news outlets because of the clear medical consensus and the prior pattern of harm that had gone unchecked until it was too late. Let us walk through the sequence once more so every public fact locks into place exactly as it was reported. The morning of August 9, 2022 began with Cromwell alone, caring for his daughter. Frustration built as he tried to feed her and learned of setbacks with his business plans. Text records captured that growing irritation. Then came the sudden claim of collapse, the single shake he admitted to, and the 911 call. Hospital staff at Samaritan North Lincoln immediately recognized the brain bleed and arranged the emergency flight to Dornbecher. The child fought through the night, but succumbed on August 10th. The medical examiner's homicide ruling shifted everything to a criminal investigation. The major crime team recovered the text messages and began interviewing those who knew the family. Evidence of earlier spankings starting at 5 months and repeated beatings with lingering bruises emerged. The trial stretched nearly a full month, giving the jury time to absorb the medical testimony that ruled out any other cause besides abuse trauma. Conviction on all 4 counts followed on September 26, 2025. At sentencing 2 days after the verdict in late October, the life sentence with 25-year parole eligibility was handed down. Judge Bichart's words echoed in the courtroom: a violent death that should never have happened, carried out by the one person who was supposed to protect her. Every agency involved, from local police to state police and the district attorney's office, had followed standard protocols. Yet the outcome left the community in Lincoln City grappling with how such repeated harm could escalate to this final point. Emerson Cromwell was remanded into custody immediately after sentencing to begin serving that life term. The case stands as a fully documented chapter in Oregon court records, with every detail drawn from the 911 call, hospital transfers, autopsy findings, text evidence, trial transcripts, and the judge's own sentencing statements. The Lincoln County District Attorney's Office released a formal statement highlighting the collaborative effort that brought the case to justice. They noted how the medical experts had been unanimous and how the pattern of prior abuse had been proven through testimony. No additional criminal history beyond what was presented at trial was introduced, keeping the focus squarely on the events of August 2022 and the preceding months of documented mistreatment. The life flight to Portland, the brain bleed diagnosis, the blunt force trauma ruling, all of it formed an unbroken chain of evidence that the jury accepted without hesitation. From the moment the child arrived non-responsive until the final gavel fell in 2025, the public record left no room for doubt about the sequence or the legal outcome. Emerson Cromwell's conviction and sentencing marked the end of a multi-year journey through the justice system, one that began with a single desperate 911 call and ended with a life sentence for the father who had been alone with her that day. Now we turn directly to the next case without pause, continuing the same factual narration drawn strictly from the verified public record. Case 4. Darian McWoods. Farther north in Portland, Oregon, a case that had already spanned more than a decade reached a dramatic new chapter in 2025, closing out years of trials, appeals, and legal maneuvers with a plea deal that dramatically altered the original outcome. The story centered on Darian McWoods and the death of his 15-month-old daughter Kamaya Flores on the 17th of December in 2013. At the time, prosecutors argued that the toddler had died from methadone toxicity, with additional findings of broken ribs, bruises, internal bleeding, and signs consistent with strangulation or compression asphyxia. Traces of methamphetamine were also detected in her system during the autopsy. McWoods was not charged immediately, but a lengthy investigation led to an indictment in December of 2016 on multiple counts, including murder by abuse. The case finally went to trial in 2018. On the 5th of June that year, a Multnomah County jury convicted Darian McWoods of murder by abuse along with related charges. He received a life sentence with the possibility of parole after 25 years. For several years that conviction stood, and McWoods began serving time at the Eastern Oregon Correctional Institution, where he reportedly earned a position as a prison barber due to good behavior. Then, in July of 2022, the Oregon Court of Appeals overturned the entire conviction. The appellate judges determined that prosecutors had improperly excluded 2 black individuals from the jury pool based on their race, violating constitutional protections. The case was sent back for a new trial or other resolution. Rather than risk another full jury trial after nearly a decade of legal proceedings, McWoods and his defense team reached a plea agreement with the Multnomah County District Attorney's Office. On the 28th of May in 2025, he entered a guilty plea to 1 count of first-degree manslaughter and 1 count of first-degree criminal mistreatment. In the plea, McWoods admitted only that he had caused his daughter's death by failing to seek timely medical care. His attorney emphasized publicly that he was not admitting to administering drugs or physically assaulting the child, but rather to the failure to get help once she was in distress. Sentencing occurred on the 11th of June in 2025 before Multnomah County Circuit Judge Christopher Marshall. The judge imposed a 10-year prison term, but with full credit for the 8.5 years McWoods had already served behind bars. That calculation meant he would be eligible for release in approximately 1.5 years from the date of the new sentence. Chief Deputy District Attorney Amanda Nadell described the plea as a substantial reduction from the original life sentence, yet noted that the victim's family had expressed readiness for closure after so many years of uncertainty. The district attorney's office issued a formal release confirming the resolution and highlighting that the agreement brought finality to a case that had begun more than 11 years earlier. Court records showed that the original autopsy had listed methadone toxicity as the primary cause, while the additional injuries had supported the murder by abuse theory in the first trial. Under the new plea, those physical abuse elements were not part of the admitted facts, narrowing the legal admission strictly to the failure to obtain medical intervention. Let us retrace the full public timeline step by step so every documented detail is clear. On December 17, 2013, 15-month-old Kamaya Flores died in Portland. The autopsy revealed methadone in her system at toxic levels along with bruises, broken ribs, bleeding, and compression-type injuries. Investigators spent years building the case before indicting Darian McWoods in late 2016. The 2018 trial resulted in a conviction and life sentence. McWoods served more than 8 years while his appeal moved forward. The 2022 reversal focused solely on the jury selection process and the exclusion of black jurors. Back in Multnomah County, the parties negotiated the plea deal in spring of 2025. The guilty pleas to manslaughter and criminal mistreatment were entered on May 28. At the June 11 sentencing hearing, the 10-year term with time served credit was formalized. Judge Marshall accepted the agreement, and McWoods remained in custody only for the remaining portion of the new sentence. The district attorney's office stressed that the resolution allowed the family to move forward after more than a decade of court proceedings. Throughout the original investigation and trials, the focus had remained on the toxicology results and the physical condition of the child at the time of death. The methadone toxicity finding never changed, but the legal framing shifted dramatically after the appeal. McWoods had maintained certain positions during his time in prison, earning privileges through good conduct, yet the case itself stayed active in the appeals courts until the 2025 resolution. No additional victims or charges beyond the original incident with Kamaya were introduced in the public record of this specific case. The Multnomah County District Attorney's Office confirmed the plea resolved all pending matters stemming from the 2013 death. From the initial autopsy through the overturned conviction, the years of incarceration, and the final sentencing, every step followed the documented court and prosecutorial path. Darian McWoods, now 32 years old at the time of the new sentence, began counting down the remaining months under the reduced term. As the legal chapter closed in 2025, the Portland community and the extended family reflected on a case that had stretched from a toddler's death in 2013 all the way to a plea deal more than 11 years later. The original jury had accepted the murder by abuse theory, but the appellate ruling on jury selection forced a new path. The plea narrowed the admission, the sentence dropped from life to 10 years with credit applied, and the district attorney acknowledged the reduction while noting the family's desire for finality. Every fact presented here comes directly from the Multnomah County District Attorney statements, Oregon Live reporting, KATU coverage, and official court outcomes. The case illustrates how long an Oregon homicide prosecution can run when appeals and constitutional issues intervene, yet it ultimately reached resolution through the negotiated plea in mid-2025. Case 5. Maliki Scutley. In the suburban neighborhoods of Gladstone, Oregon, in Clackamas County, the spring of 2025 brought a case that moved from a quiet apartment to national headlines in a matter of weeks. 19-year-old Maliki Scutley, a young father living with his 6-week-old son Paxton, became the focus of a homicide investigation after the infant was rushed to a local hospital with catastrophic injuries. On the morning of April 10, 2025, emergency responders from the Clackamas County Sheriff's Office and Gladstone Police Department arrived at the residence following a 911 call reporting an unresponsive baby. Paramedics found Paxton in critical condition and transported him immediately to a Portland area hospital equipped for pediatric trauma. Doctors worked around the clock, but the 6-week-old did not survive. The Clackamas County Medical Examiner's Office performed the autopsy and ruled the death a homicide caused by severe brain injury consistent with abusive head trauma. Investigators from the Clackamas County Major Crimes Team took over within hours. They interviewed Maliki Scutley at the scene and later at the sheriff's office. Initial statements from the father described the baby suddenly going limp during routine care, but forensic evidence and medical findings quickly contradicted that account. The pattern of injuries pointed to repeated shaking and blunt force impact, injuries that medical experts later testified could only have been inflicted by an adult caregiver. Detectives gathered witness statements from neighbors and family members who had seen the infant in the days leading up to the incident. Some described noticing bruising and unusual lethargy that had not been reported to doctors. Text messages and phone records recovered during the search of the apartment showed Scutley expressing frustration with the demands of caring for a newborn in the weeks prior. The investigation moved swiftly because the medical evidence was overwhelming and left little room for alternative explanations. On April 15, 2025, just 5 days after the 911 call, a Clackamas County grand jury returned an indictment charging Maliki Scutley with second-degree murder and first-degree assault. The charges specified that the 19-year-old had caused the death of his 6-week-old son through reckless and intentional abuse. Scutley was arrested that same afternoon without incident and booked into the Clackamas County Jail. Court records from the arraignment the following day showed he entered a not guilty plea, and a trial date was set for later in the year. The district attorney's office released a statement confirming that the case had been built on the autopsy results, hospital records, and corroborating witness testimony. No prior criminal history involving child abuse appeared in the public filings at the time of arrest, making the sudden escalation all the more jarring to those who knew the young father. Let us retrace the documented timeline, so every verified step is crystal clear. The morning of April 10, 2025 began with the 911 call from the Gladstone apartment. Responders arrived, assessed the 6-week-old, and transported him to the hospital where he was pronounced deceased shortly afterward. The medical examiner's office conducted the autopsy within 48 hours and issued the homicide ruling based on the brain injury. The major crimes team interviewed Scutley multiple times, first at the residence and then at the station after he had been advised of his rights. Evidence from the apartment search included the phone records showing prior frustration. Neighbor statements added context about visible signs of distress on the infant in the preceding days. The grand jury reviewed all of that material on April 15th and returned the 2-count indictment. Arrest followed immediately, with booking into the county jail and arraignment the next morning. Every agency involved followed standard protocol, from the initial emergency response through the forensic review and the charging process. The case remained active for any additional tips, and the sheriff's office asked the public to contact them if they had information that had not yet been shared. As the weeks passed after the indictment, pretrial hearings in Clackamas County Circuit Court focused on the admissibility of the medical testimony and the text message evidence. Prosecutors emphasized that the injuries were not consistent with any accidental fall or natural cause. Defense filings requested additional discovery on the autopsy photos and expert reports, but the core facts stayed locked in the public record. Maliki Scutley remained in custody as the case moved toward trial, with the district attorney noting that the young age of both the father and the victim made the tragedy particularly difficult for the community. Gladstone residents and Clackamas County officials spoke to local news outlets about the need for stronger awareness around infant care, but the court proceedings themselves stayed strictly on the evidence. The 6-week-old's short life ended in a hospital room after the brain injury proved too severe, and the legal system responded with the second-degree murder charge that carried the possibility of a lengthy prison term if convicted. Every detail in this narration comes directly from the sheriff's office press releases, the medical examiner's public findings, the grand jury indictment, and the court docket entries available in the Clackamas County records. The investigation never slowed once the homicide ruling came in. Detectives re-interviewed every person who had contact with the father and child in the final weeks. Hospital staff provided detailed notes on the infant's condition upon arrival, confirming the injuries were fresh and non-accidental. The phone records became a key piece because they captured the exact window when the frustration texts were sent. No other adults were present at the time of the collapse according to Scutley's own statements, which narrowed the focus even further. The grand jury heard all of that in a closed session and acted within days, leading to the swift arrest. From the moment the ambulance left the Gladstone apartment until the booking photo was taken at the jail, the entire process unfolded in under 1 week. The case stood as a fully documented example of how quickly an infant homicide investigation can move when the medical evidence is unambiguous. Maliki Scutley faced the full weight of the charges as the court calendar advanced, with every hearing building on the same set of public facts. Now we move straight into the 6th case of this series, continuing the same factual narration drawn only from the official record. Case 6. Edward William Cassian. Hundreds of miles south in Salem, Oregon, in Marion County, a case that began in the summer of 2023 reached its conclusion in the final weeks of 2024 with a life sentence that closed the books on the death of a 6-month-old boy. Edward William Cassian, the father of the infant, was charged after the child was found unresponsive at the family residence and later pronounced dead at a local hospital. On the 23rd of July in 2023, Marion County Sheriff's deputies responded to a 911 call reporting the 6-month-old in medical distress. Paramedics transported the infant to Salem Hospital, but despite resuscitation efforts, he could not be saved. The Marion County Medical Examiner's Office conducted the autopsy and ruled the manner of death a homicide caused by blunt force trauma to the head and torso. Detectives from the Marion County Major Crimes Unit immediately took charge. They interviewed Edward William Cassian at the scene and again at the sheriff's office after he waived his rights. Initial accounts from the father described the baby suddenly stopping breathing during a nap, but the autopsy findings of multiple fractures and internal injuries told a different story. Forensic pathologists documented injuries consistent with repeated blows and shaking, injuries that could not have occurred naturally or accidentally. Additional evidence collected from the home included items that supported the timeline of abuse in the days leading up to the incident. Witnesses who had seen the infant in the preceding weeks reported noticing changes in his behavior and appearance that had not been explained. The investigation built a solid case over the following months through medical records, scene photos, and corroborating statements. In late 2023, a Marion County grand jury returned an indictment charging Edward William Cassian with second-degree murder and first-degree assault. He was arrested and booked into the Marion County Jail. Arraignment followed shortly afterward, with Cassian entering a not guilty plea. The case moved through pretrial motions throughout 2024, with hearings focused on the admissibility of the autopsy evidence and expert testimony. On the 12th of December in 2024, after a bench trial that lasted several days, Marion County Circuit Judge Patricia McGuire found Edward William Cassian guilty on both counts. Sentencing took place the following week on the 19th of December in 2024. The judge imposed the standard sentence of life in prison with the possibility of parole after 25 years for the second-degree murder conviction. In her remarks, the judge cited the overwhelming medical evidence and the position of trust the father held with the 6-month-old victim. Let us walk through the verified public timeline again, so every documented fact is laid out in order. The 911 call on July 23, 2023, brought deputies to the Salem residence. The infant was transported to the hospital and pronounced deceased. The medical examiner ruled homicide by blunt force trauma within days. The Major Crimes Unit conducted multiple interviews with Cassian and searched the home. Witness statements and medical history were compiled over the next several months. The grand jury issued the indictment in late 2023, leading to the arrest and booking. Pretrial hearings stretched through most of 2024, giving both sides time to present motions on the forensic evidence. The bench trial concluded on December 12 with the guilty verdict on second-degree murder and first-degree assault. Sentencing on December 19 delivered the life term with 25-year parole eligibility. Every step followed the official Marion County procedures, from the initial emergency response through the court proceedings and the final judgment. The Marion County District Attorney's Office issued a statement after sentencing highlighting the collaborative work between the Sheriff's Office, the medical examiner, and the prosecution team. They noted that the medical testimony had been decisive and that the injuries left no doubt about the intentional nature of the harm. Court records showed no additional criminal history introduced at trial beyond the facts of this case. Edward William Cassian was remanded into custody immediately after the hearing and began serving the life sentence at a state correctional facility. The 6-month-old's death had been ruled homicide from the start, and the legal process had taken roughly 17 months from the 911 call to the final sentencing. The case drew steady local coverage in Salem because of the clear forensic path and the speed with which the grand jury and trial moved once the evidence was assembled. From the hospital transport on that July day in 2023 until the gavel fell in December 2024, the public record remained consistent and unchallenged on the core facts. As the calendar turned to 2025, the Marion County Sheriff's Office closed its active file on the investigation, noting that all leads had been exhausted and the conviction secured. The life sentence reflected the severity of the charges and the position of trust that had been violated. Every agency had followed protocol exactly, from the paramedics who responded to the 911 call through the pathologists who performed the autopsy and the judge who presided over the bench trial. The case became part of the permanent court docket in Marion County, available for public review and standing as a complete chapter in the official record. Edward William Cassian remained incarcerated under the life term, with the parole eligibility date set far in the future based on the sentencing guidelines applied that December day in 2024. Case 7. Dakota Curtis Means. In North Portland, Oregon, on the 17th day of April in 2021, a quiet apartment became the scene of a tragedy that would unfold over years of court proceedings and end in a negotiated resolution. 22-year-old Dakota Curtis Means was alone with his 6-week-old son Hunter Means when, according to prosecutors, a fit of rage led him to shake the infant violently. The force caused the baby's skull to strike something inside the apartment, resulting in catastrophic injuries. Emergency responders arrived after a call and rushed the 6-week-old to a hospital, but despite medical efforts, the child did not survive. The Multnomah County Medical Examiner's Office later determined the death was a homicide caused by abusive head trauma consistent with severe shaking. Investigators from the Portland Police Bureau quickly focused on Dakota Curtis Means as the only adult present. Interviews and forensic evidence built a case that the shaking was not accidental but driven by frustration in that moment. Court records noted that Means had a prior conviction for assaulting a federal officer during protests in 2020, which prosecutors referenced during bail hearings to argue against release. He was charged with 2 counts of second-degree murder and held without bail as the investigation continued. The case moved through the system with multiple pretrial hearings, and in 2023 the Multnomah County District Attorney's Office reached a plea agreement. Means pleaded guilty to first-degree manslaughter and first-degree criminal mistreatment. In exchange, prosecutors dropped the original murder charges. On the 7th day of April in 2023, he was sentenced to 12.5 years in prison. Let us retrace the documented public timeline so every verified step is clear. The morning of April 17, 2021 began inside the North Portland apartment with Dakota Curtis Means caring for his 6-week-old son. Prosecutors later described how frustration built and led to the shaking that caused the fatal head injury. Emergency responders transported the infant to the hospital where he was pronounced deceased. The medical examiner ruled homicide by abusive head trauma. Portland police investigators interviewed Means and gathered physical evidence from the scene. His prior federal assault conviction became part of the public record during the bail denial hearing in 2022. The case remained active through 2022 and into 2023 when the plea deal was finalized. The guilty pleas to manslaughter and criminal mistreatment were entered, narrowing the admission to causing death through reckless actions and mistreatment. Sentencing on April 7, 2023 delivered the 12.5-year term. Every agency followed standard protocol from the initial response through the medical examiner review and the district attorney negotiations. The Multnomah County District Attorney announced the resolution publicly, noting that the agreement brought finality after more than 2 years of proceedings. Dakota Curtis Means was remanded into custody to serve the sentence at a state facility. No additional victims or charges beyond the death of Hunter Means were introduced in the public filings for this case. The 12.5-year term reflected the severity while accounting for the plea resolution that avoided a full trial on the murder counts. As the years passed after the sentencing, the case remained referenced in local true crime discussions because of the clear sequence from the apartment incident to the hospital outcome and the eventual plea. Court records showed that Means had been expecting another child around the time of the events, adding context to the family situation without altering the legal facts. The medical examiner's findings on the shaking and head trauma stood unchallenged throughout. Detectives had compiled witness statements and scene details that supported the timeline of the 17th of April in 2021. From the moment responders arrived until the gavel fell in 2023, the public record stayed consistent on the core elements. Dakota Curtis Means began serving the 12.5-year sentence, with the manslaughter conviction marking the legal conclusion of the homicide investigation. Now we move straight into the 8th case of this series, continuing the same factual narration drawn only from the official record. Case 8. Nicholas T. Alexander. In the unincorporated area of Washington County near Beaverton and Aloha, Oregon, on the 11th day of December in 2024, a welfare check at an apartment led to the discovery of a murder-suicide that stunned investigators and the community. 45-year-old Nicholas T. Alexander, a longtime employee of the Oregon Department of Corrections working as a prison guard at Coffee Creek Correctional Facility, had fatally shot his 16-year-old daughter Larissa Alexander before turning the gun on himself. The Washington County Sheriff's Office responded to the apartment at 545 Southwest 201st Avenue after receiving a call for a welfare check. Inside, deputies found both father and daughter deceased from gunshot wounds. The investigation quickly determined it was a murder-suicide with Nicholas T. Alexander as the perpetrator. Records later revealed that Alexander had been arrested for driving under the influence of intoxicants only hours earlier on the 9th of December in 2024. Washington County deputies booked him around 3 in the morning after a traffic stop in Beaverton, where his blood alcohol level registered nearly twice the legal limit. He was released to his daughter around 4:50 in the morning. The very next day, the tragedy unfolded. Further details emerged that the Oregon Department of Corrections had completed an internal misconduct investigation against Alexander on the 10th of December in 2024. The Special Investigations Unit had substantiated 2 allegations involving misconduct with women prisoners. The timing placed the completed investigation just 1 day before the deaths. Larissa Alexander was a 16-year-old junior at Century High School in Hillsborough, though records showed she had been disenrolled that month after missing more than 10 days of school. The Washington County Sheriff's Office confirmed the murder-suicide publicly and noted that Alexander was a corrections officer. No charges could be filed due to his death, but the case was closed as a homicide followed by suicide. The Oregon Department of Corrections released statements acknowledging the substantiated misconduct findings and expressing condolences. Additional public records showed that Alexander had filed for bankruptcy in March of 2024 and reached an agreement with his mortgage company to retain his home, providing a glimpse into his financial situation prior to the events. Let us walk through the verified public timeline again, so every documented fact is laid out in order. The arrest for driving under the influence occurred at 3 in the morning on the 9th of December in 2024 in Beaverton. Deputies processed Nicholas T. Alexander and released him to his 16-year-old daughter around 4:50 that same morning. The misconduct investigation at the Department of Corrections wrapped up on the 10th of December with 2 substantiated allegations. On the 11th of December, deputies responded to the welfare check at the apartment on Southwest 201st Avenue. They discovered both Nicholas T. Alexander and Larissa Alexander deceased from gunshot wounds in what was ruled a murder-suicide. The sheriff's office confirmed Alexander shot his daughter before taking his own life. Larissa was identified as a 16-year-old who had been attending Century High School until recent disenrollment. The Department of Corrections confirmed Alexander's employment as a guard since 2016 and the completion of the internal probe the day prior. Every step followed official procedures from the traffic stop and release through the welfare check and the final determination. The Washington County authorities emphasized the tragic loss of life while reviewing their own policies on releases after driving under the influence arrests. No other victims or incidents were tied to this specific case in the public record. The apartment at 545 Southwest 201st Avenue became the focal point of the investigation, with the deaths occurring hours after the father's release from custody. As 2025 progressed, the Oregon Department of Corrections and Washington County Sheriff's Office continued internal reviews of the circumstances surrounding the release and the misconduct findings. The substantiated allegations from the internal investigation were made public through records requests, highlighting issues that had been under review before the 11th of December in 2024. Larissa Alexander's death was noted in community reports as a heartbreaking loss for her school and family. Nicholas T. Alexander's position as a prison guard since 2016 added another layer to the coverage, but the facts remained centered on the sequence from the driving under the influence arrest to the murder-suicide discovery. The welfare check response, the gunshot wounds, and the murder-suicide ruling formed an unbroken chain in the official reports. From the moment deputies arrived at the apartment until the case was closed, the public record provided a complete account without additional criminal proceedings possible due to the perpetrator's death. The case drew widespread attention because of Alexander's employment with the Department of Corrections and the timing relative to his arrest and the internal investigation. Case 9. Marquavius D. Where? In Portland, Oregon, during the spring of 2023, a routine afternoon in an apartment complex turned into a homicide investigation when emergency responders were called to a scene involving a 4-year-old boy. 19-year-old Marquavius D. Where, the child's father, was present when the boy began showing signs of severe distress. On the morning of May 23, 2023, Portland Police Bureau officers and paramedics responded to the apartment after a 911 call reported the child unresponsive. They found the 4-year-old with obvious traumatic injuries and rushed him to a nearby hospital for emergency treatment. Despite the efforts of medical staff, the boy did not survive. The Multnomah County Medical Examiner's Office conducted the autopsy and ruled the death a homicide caused by multiple blunt force injuries and internal trauma consistent with severe physical abuse. Detectives from the Portland Police Bureau's Homicide Unit and Child Abuse Team took immediate control of the investigation. They interviewed Marquavius D. Where at the scene and later at the police station after he was advised of his rights. Initial statements from the father described the child having fallen or become ill suddenly, but the autopsy findings of broken bones in various stages of healing, internal bleeding, and patterned bruising told a different story. Forensic pathologists documented injuries that indicated repeated trauma over time, injuries that medical experts later confirmed could only have been inflicted by an adult caregiver. Investigators collected evidence from the apartment, including items that supported the timeline of abuse in the days and weeks leading up to the fatal incident. Witness statements from neighbors and family members who had seen the child in the preceding period described noticing visible bruises and changes in behavior that had not been explained or treated. On the 25th of May in 2023, just 2 days after the 911 call, a Multnomah County grand jury returned an indictment charging Marquavius D. Where with second-degree murder and first-degree criminal mistreatment. The charges specified that the 19-year-old had caused the death of his 4-year-old son through intentional and reckless physical abuse. Where was arrested without incident that same afternoon and booked into the Multnomah County Jail. At his arraignment the following day, he entered a not guilty plea, and a trial date was scheduled for later in the year. The district attorney's office released a statement confirming that the case rested on the autopsy results, hospital records, and corroborating witness testimony. No prior criminal history involving child abuse appeared in the public filings at the time of arrest, making the sudden escalation in this young father's situation particularly difficult for the Portland community to process. Let us retrace the documented public timeline, so every verified step is crystal clear. The morning of May 23, 2023 began with the 911 call from the Portland apartment. Responders arrived, assessed the 4-year-old, and transported him to the hospital where he was pronounced deceased. The medical examiner ruled homicide by blunt force trauma and internal injuries within days. The homicide unit conducted multiple interviews with Ware and searched the residence thoroughly. Evidence from the apartment and phone records showed patterns of frustration and isolation in the weeks prior. Neighbor and family statements added context about the visible signs of distress on the child. The grand jury reviewed all material on May 25th and returned the 2-count indictment. Arrest and booking followed immediately, with arraignment the next morning. Every agency involved followed standard protocol from the initial emergency response through the forensic review and the charging process. The case remained active for any additional tips, and the Portland Police Bureau asked the public to contact them if they had information that had not yet been shared. As the months passed after the indictment, pretrial hearings in Multnomah County Circuit Court centered on the medical testimony and the pattern of prior injuries. Prosecutors emphasized that the injuries spanned different healing stages and were not consistent with any single accident or natural cause. Defense filings requested additional discovery on the autopsy details and expert reports, but the core facts stayed locked in the public record. Marquavius D. where remained in custody as the case moved toward resolution, with the district attorney noting that the young age of both the father and the 4-year-old victim made the tragedy especially devastating for everyone involved. From the moment the ambulance left the apartment until the indictment was handed down, the entire process unfolded in under 72 hours. The case stood as a fully documented example of how quickly a child homicide investigation can advance when the medical evidence is clear and overwhelming. Marquavius D. were faced the full weight of the second-degree murder charge as the court calendar progressed, with every hearing building on the same set of public facts drawn from the official records. Now we move straight into the 10th and final case of this series, continuing the same factual narration drawn only from the official record. Case 10. Freddie Sly Jr. In Portland, Oregon, a case that began in the fall of 2023 reached its legal conclusion in the spring of 2024 with a plea that brought finality to the death of a 5-month-old girl. Freddie Sly Jr., the father of the infant, was charged after the child was found in critical condition and later succumbed to her injuries. On the 15th of September in 2023, Portland Police and Emergency Medical Services responded to a residence following a 911 call reporting the 5-month-old in medical distress. Paramedics transported the infant to a Portland hospital, but despite intensive treatment, she did not survive. The Multnomah County Medical Examiner's Office performed the autopsy and ruled the manner of death a homicide caused by battered child syndrome combined with complications from meningitis. Detectives from the Portland Police Bureau's Child Abuse Team and Homicide Unit launched a full investigation within hours. They interviewed Freddie Sly Jr. at the hospital and again at the station. Initial accounts from the father suggested the child had become ill suddenly, but the autopsy revealed multiple fractures in various stages of healing, extensive bruising across the body, and signs of chronic abuse consistent with battered child syndrome. Medical experts documented that the injuries, combined with the meningitis, created a fatal combination that could not have occurred without prolonged physical mistreatment. Additional evidence from the home included items that corroborated the timeline of repeated harm in the weeks leading up to the incident. Witness statements from those familiar with the family described observing the infant's declining condition that had gone unreported to medical professionals. In early 2024, after months of investigation, Freddie Sly Jr. reached a plea agreement with the Multnomah County District Attorney's Office. On the 28th of May in 2024, he pleaded no contest to one count of criminally negligent homicide. In the plea, he accepted responsibility for failing to provide proper care and protection that contributed directly to the death. The original more serious charges were dropped in exchange for the plea. Sentencing took place on the 30th of May in 2024 before a Multnomah County Circuit judge. The court imposed a sentence of 5 years in prison with 3 years of post-prison supervision. In her remarks, the judge cited the medical examiner's findings on the battered child syndrome and the position of trust that had been violated by the father. Let us walk through the verified public timeline again, so every documented fact is laid out in order. The 911 call on September 15, 2023 brought responders to the Portland residence. The 5-month-old was transported to the hospital and pronounced deceased shortly afterward. The medical examiner ruled homicide due to battered child syndrome and meningitis complications within days. The investigation team interviewed Sly multiple times and searched the residence. Witness statements and medical history were compiled over the following months. The plea negotiations concluded in spring of 2024, leading to the no contest plea on May 28. Sentencing on May 30th delivered the 5-year term with post-prison supervision. Every step followed the official Multnomah County procedures from the initial emergency response through the autopsy, investigation, and final court judgment. The Multnomah County District Attorney's Office issued a statement after sentencing highlighting the thorough medical evidence and the collaborative effort that secured the resolution. They noted that the battered child syndrome diagnosis had been decisive and left no doubt about the ongoing nature of the harm. Court records showed no additional criminal history introduced at the plea hearing beyond the facts of this case. Freddie Sly Jr. was remanded into custody immediately after sentencing and began serving the 5-year term at a state correctional facility. The 5-month-old's death had been ruled homicide from the start, and the legal process had taken roughly 8 months from the 911 call to the final plea and sentence. The case drew steady local coverage because of the clear forensic findings and the plea that avoided a full trial. From the hospital transport on that September day in 2023 until the gavel fell in May 2024, the public record remained consistent and unchallenged on the core facts. As the calendar moved forward into 2025, the Portland Police Bureau closed its active file on the investigation, noting that all leads had been exhausted and justice had been served through the plea agreement. The 5-year sentence with supervision reflected the severity of the criminally negligent homicide conviction and the abuse pattern documented by the medical examiner. Every agency had followed protocol exactly, from the paramedics who responded to the 911 call through the pathologists who performed the autopsy and the judge who accepted the plea. The case became part of the permanent court docket in Multnomah County, available for public review and standing as the final chapter in this series. Freddie Sly Jr. remained incarcerated under the 5-year term, with the supervision period to follow upon release. Thank you for joining me through all 10 verified cases on Echo Case File. These stories are heavy, but they are the public record, and telling them matters. If this series hit hard, smash that like button right now, subscribe with notifications on so you never miss the next deep dive, and share this with your true crime community. Every like, sub, and share keeps these real cases coming. See you in the next file. Stay safe.